Good afternoon. I'm Dr. Andrea Chisholm, Deputy Director of Strategic Planning and Resource Development of the American Insurance Trust, known to most of you simply as the Trust. I'm filling in for Dr. Jana Martin today, who is attending the California Psychological Association Convention, and I'm delighted that you're able to join us for our next webinar. As a trust policyholder, most of you are likely familiar with our risk management consultation service, the Advocate 800 program. It's one of many benefits our insureds receive through the trust. Three of our advocates are with us today, Drs. Eric Harris, Mark Martinez, and Lisa Bryant. I hope you benefit immensely from this risk management roundtable. Please join me in welcoming Drs. Bryant, Harris, and Martinez.
Thanks so much, Dr. Chisholm. We're delighted to be back here with you all and looking forward to a good roundtable. As usual, we will start with a few questions that have come in advance, and then we will quickly pick up with your live questions. So as we're talking, if you're welcome to go ahead and put your live questions into the Q&A box, and we will get to those here in just a few minutes. So that being said, Mark, we'll start with you. We'll jump right in. As you know, we've been getting a lot of calls on interjurisdictional practice and in particular on SIPACT. So maybe if you can just note quickly what that is, provide some resources related to SIPACT, and then say a few things about what clinicians need to be considering when they're thinking of whether or not to use SIPACT, and if they are using it, what are some of the risk management considerations?
Sure, yeah. So I strongly urge those interested in SIPACT to review the information located on the SIPACT website. This information will be helpful to complement the synopsis that I'll provide. But in general, to start, SIPACT is an interstate compact. It's been operational since July of 2020. And these interstate compacts are those enforceable contracts that are made between the states. Now, these are permitted by the US Constitution, and the US Constitution grants the states the right to enter into multi-state agreements for their own common benefit. And as of today, there are 40 states where SIPACT has been enacted. Now, SIPACT was established as a process where licensed psychologists from a state participating in SIPACT can apply for it and receive 1 or 2 credentials. These include a telepsychology option and an in-person option for practice. Now, for the purpose of today's discussion, decided to focus on the telepsychology option because it's most frequently what we discuss during our calls. So under the telepsychology option, there's what they call a home state requirement. And that demands that holders practicing under the telepsychology option be physically located in their home state and practicing into another participating state. So a home state is the state where a psychologist is licensed. That state participates in SIPACT, and it's identified by the psychologist as their home state and where they'll be located when they're providing telepsychology services. So for example, if I'm a member of SIPACT and solely licensed in Pennsylvania, I would identify Pennsylvania as my home state, and this would limit me to seeing patients or clients in participating SIPACT states using telepsychology as long as I'm located in Pennsylvania. If I was to leave Pennsylvania, I cannot provide telepsychology services under SIPACT. So because of the different rules, laws, and regulations between states, it's very important to be aware of those practice expectations prior to providing services. It's also very important to ensure that your documents, your policies and procedures, for example, your informed consent, reflect these state-specific requirements. So this means if I'm practicing into another state, my practice will need to be consistent with the applicable state's rules, laws, and regulations. As an example, if I was practicing into Texas, it'd be important for me to understand that there's no required breach of confidentiality for dangerousness. It's also important to understand that there are limits under SIPACT. So as an example, SIPACT does not allow supervision under the telepsychology option. In order to gain insight into the rules, laws, and regulations, it can seem a little bit overwhelming, but there are some resources that are available. By going to the SIPACT site, there's some information, especially under the Commission tab. You can consult with the trust, risk managers, or your own professional liability provider. You can consult with your state board of psychology or even the leadership of your state psychological association, consult with an experienced colleague, or with an attorney in the applicable states.
Great, thanks, Mark. You covered a lot very quickly there. That's beautiful. Eric, anything you want to add to that?
Well, as I said when we were rehearsing a little, I think that there's a number of issues with SIPAC, which means that people should be very careful about deciding to join it. If you have a good established practice in the state that you're in, and many psychologists now have that, particularly after the pandemic, I think that you should be careful, because by joining SIPAC, you lose certain things that you would have if you aren't a member of SIPAC. For example, if you're licensed in more than one jurisdiction, you would be able to practice in those jurisdictions. You wouldn't have to have a home state. You can practice from those jurisdictions. Also, the fact that it is a consortium that SIPAC is, it will be very difficult to change the rules politically. When states were making the laws through their licensing board, through regs, if your state association had influence with those things, and often if there were problems, you could get the rules changed. That's not going to happen with SIPAC. So those are two things that I wanted to say.
Yeah, that's great. I think it's really important for folks to think about this. And of course, the decisions will be really specific to the practitioner, right? In terms of which pros and cons matter the most for them. Mark, I also wanted to underscore something you said about when you talked about, knowing the state laws where you're practicing into. So not just your home state, but the receiving state. And, especially like, let's take your Texas example, right? Important that the clinician, your informed consent documents reflect the receiving state laws. So when you're practicing under SIPAC and you're seeing people in other states, you can't just assume that your informed consent for your home state will be accurate and relevant for every other state you practice into. So these are just some of the many things that you have to really think about, right? Eric, did you want to add something?
Yeah, there's no database available through SIPAC. So figuring out what the laws are in the other states is something that I don't know how people are going to do easily, because there isn't any real guidance to that. And that's one of the things I think is the most problematic about the rules.
Yeah, it's a complicated issue. So, okay, great. So I'm assuming there'll be more questions about this coming in, but we're going to move on to our next question. And Eric, I'll take this one to you. What is the best approach to maximizing confidentiality between teenagers and parents when, say, the teenager is the patient?
Well, the easy answer to that is a good, solid, informed consent contract, the most important part of which is an agreement that the parents will not seek information about their children from the therapist. It's very important that that contract be in writing, because HIPAA then actually says that that contract is a binding contract with regard to requests for information from the therapist, even if the parents change their mind. Of course, this is sometimes very difficult if parents are fighting with each other or divorced or not clear about their desires for the therapy to be a certain way. And often if they sometimes can fight with each other around the issues of therapy about their child. So it's very important to try to get this if you can. If you can't, then the question becomes, is it worth continuing to take the case? And that's an individual judgment. I know some therapists do and some therapists don't want to do that. The pitch to the parents has to be that when you're treating an adolescent, privacy is very important, because if the parents don't agree to let the confidentiality in the relationship stand, their adolescent child is not going to tell the therapist anything. I remember when I was an adolescent, I certainly wouldn't have told a therapist information that I thought my parents, would get. The other part of that contract, and all of this is contained in our model contract on the trust website, which is going to be put on the, what is it? Which thing is it in?
It'll be in the chat box.
Chat box, excuse me. That the parents agree that if there is any legal dispute between them, they will not call the therapist to participate in that legal process, thereby protecting the child from being put in the middle or feeling that somehow they're being asked to make a decision that will affect their relationship with one or the other parent. That's it.
All right, terrific, thank you. Mark, anything you want to add to that?
No, the only thing that comes to mind is the issue around privacy, about that zone of privacy. We've discussed this as a group before, and I really like, I think it was both Eric and Lisa, you had the recommendation that using a collaborative approach to define what these limits might look like with both the minor and their parents can help set expectations and some of those boundaries, so that we know when we're treading toward this dangerousness that may be disclosed during treatment, that the expectation is that we will have to share this with parents, but hopefully the parents will respect privacy short of that zone.
And I just want to add that I forgot that, but that is very important. The more you can have an agreement in advance about what the rules are, the better the therapy is likely to be. Also, that process, if you can get to have a conversation with the adolescent and the parents, is in itself very therapeutic. It's often a situation where the parents and the adolescent have never had such a conversation as directly as that. So that's very important. And thank you for reminding me, Mark.
Yeah, and I agree with both of you. I often, when we have callers, recommend this too. Like, if at all possible, get all parties in the room together, talk about this, and then give explicit examples. Like, if your teen talks to me about substance use or talks to me about sexual experimentation, which of course is normal for teens, right? What of that will you share with parents? What of that will you not? And state some examples openly, so that if the parents say, no, if my teen has any sexual experimentation, I want to know. Well, you need to know that at the onset, right? You don't want to be 6 months in and end up in a difficult situation, right? So yeah, this is exactly important, I think.
Yeah, but let me just say one more thing. Like, let's take marijuana, for example. A parent might not want to know if a child occasionally experiments with their peer group, but if the child is smoking every day, that's a different situation. And that would be something which probably would require you to tell the parents. And if you have a question about that, that's a great time to consult with one of the trust risk managers.
Absolutely. No, and that's great. I think giving examples on sort of each end of the continuum, like, this is something I as a therapist would likely not tell a parent about, versus this is something I definitely would, right? And so everyone can respond. So great. All right. Thank you, guys. Mark, we'll come to you, because we've also been getting lots of questions and callers who are noticing an increase in requests for records, and coming from lots of different sources, sometimes attorneys, insurance companies, audits, all sorts of different sources. But can you say something about what clinicians generally, so I know this is a very broad, and release of records can get specific, but can you give us some general considerations for what clinicians need to think about when they're asked to release their record?
Yeah, certainly. And so as the starting point, I think it's important to ask some clarifying questions. Who is the patient for the client? Who has the authority to access or control disclosure of the health records? And what type of record is being requested? For example, are we talking progress notes? Are we talking psychological testing or psychotherapy notes? They all have different responses that may be triggered. So we want to keep in mind that sometimes determining who the client is will depend upon state law. So in some states, they have what they call mature minor laws that allow minors of a certain age to consent to treatment absent apparent consent. And there are certain thresholds or standards that must be met, oftentimes, that accompany that status that you would have to show and support. Sometimes determining who the client is will depend on the circumstances. So a third-party evaluation, such as a court-ordered evaluation, will change that dynamic. So remember that records, though, even if you have a client who's behind on payment, they have a balance, and they request their record themselves or to be released to a third party, non-payment for those services is not grounds for withholding records. Keep that in mind. In most circumstances, the release of records will be fairly straightforward. So if they're being asked to send them to a third party, this will require authorization from the relevant party or parties. Most commonly, this is going to be the patient or their legal representative or representatives, such as parents with legal decision-making authority for a minor. And remember that a patient or client or their legal representatives can revoke a previous authorization. And a treatment provider can also suggest this as an option if there are concerns about releasing a record to a third party. But ultimately, we want to keep in mind that the patient or the representative, they are the ones that are in the driver's seat. And if a treatment provider wants to deny access to a record because of serious concerns, whether it's danger to the patient or client or others, you're going to want to look very closely at HIPAA and state law expectations. For example, in Massachusetts, there is a law that restricts the release of a minor's records in divorce cases. We also want to keep in mind that there are going to be standards and procedures that we have to follow if we are seeking to deny access to a record, because overall, we favor disclosure of records to the patients. So to navigate this process and the complexities, it's often worth considering consultation with a local attorney. Keep in mind, in the case of an insurance company requesting information, we want to follow that minimum necessary disclosure standard, which is largely going to depend upon professional judgment. And just because an attorney representing a patient or client requests a record, that doesn't mean that we just turn it right over. We're also going to want to still seek authorization from our patient and client. And to assist in clarifying these issues with the client and the patient, recommend that your informed consent detail each party's role, who has authority to access the record, and how disclosures will be made. And as we've said before, there are several templates on the document library on the Trust website. And lastly, if you're not sure about whether it's acceptable to release a record, it's generally not very risky to withhold, at least until the issue is clarified and you've been able to research and consult on the next best steps.
Mm-hmm. Great. Yeah, I agree. Always better to be conservative until you know, right? Rather, because you can't unring the bell, so to speak. Eric, anything you want to add to that?
Well, just going back to the very first question, which was SIPAC. Maryland and Massachusetts have very strict rules about not releasing adolescent records without an appointment of a special representative to represent the interests of the kids. So the parents can't do it. If you're in another state as a SIPAC member and practicing into those states, the question is, how would you find out that that was a rule? It's not apparently easy to do that, and you could get in real trouble by releasing records in that situation where the law is, where it is against the law in that jurisdiction.
Mm-hmm. Yeah, no, I know we're back on SIPAC, but I think that is a really important point, because it does, you know, for those practicing under SIPAC, there's going to have to be a little extra homework done, and it's not easy. You know, and so again, coming back, I know both Eric and Mark have said this a couple times, but consulting with us, consulting with attorneys, consulting even perhaps with state psych associations or their ethics committees, you know, are some resources, and hopefully over time there additional resources will be developed. But as of yet, there's not one clear bank of information.
Can I add one more thing?
Yes, please.
Lots of times people call and they say, I don't think it's a good idea for this client to release the records. And they ask, is there anything I can do about that? And what I say to them then is, you can certainly talk to the client, and you should talk to the client about why you think it's a bad idea. They have a right to change their mind. They can always revoke that. And oftentimes that they don't really think about what the consequences are in terms of how it might interfere with their therapy or their other relationships to have that released, particularly when they're involved in a lawsuit and they haven't, the lawyer isn't going to tell them about the psychological impact of releasing the records or being participating in that way.
Yeah, I think that's a really great point. I would add to that, and Mark, I'd be interested in your thoughts on this too, but I think it's really important for the clinician to talk about how it will impact therapy. I think we also have to be careful as psychologists not to tell the patient how it's going to impact their legal case. Because I've had some callers that want to say, oh, this record is completely irrelevant to your legal case. But we as psychologists don't usually know that, you know, so we want to be careful to stay in our lane on that. Mark, anything else on records before I move on there?
No, nothing comes to mind.
Great. All right, Eric, then we'll take the last pre-question, so to speak, to you before we dive into the live questions. As you know, it's not uncommon for a treating clinician to either be asked by the patient or to receive a subpoena to participate in some capacity in a divorce or a custody parental fitness hearing, that kind of thing, and to be asked to give opinions on that, right? Custody, fitness, parental fitness, visitation, those kinds of things. What do you recommend for clinicians who are being asked that, whether it's being asked by the client or an attorney, or they've actually received now a subpoena to testify?
Well, it's really important to know that if you have a contract with the parents, that is not binding on the court. So if the parent agrees that they are not going to involve the therapist in the proceeding, often they'll change their minds based on the advice of their lawyers. Probably their lawyers will not usually advise them to violate that contract because it makes it look like they're not really interested in their child's best interest. And since the contract pretty much describes the purpose of the contract is protecting the child from being in the middle between the parents in a divorce or custody situation, that's very important. The other thing is that you sort of, to answer this question, it kind of requires you to talk about what a therapist's role is as a witness and what a therapist can and can't testify about. The only opinions that therapists are allowed to give if they're a witness in any kind of proceeding is what their diagnosis is, what their treatment plan is, what the prognosis is, and opinions that they formed in order to do the treatment that they're doing. They can't give opinions on other things, even if they have some expertise in other areas. They can't, for example, give an opinion about whether this parental behavior is problematic in some ways. The rule of thumb when you are participating in a custody or visitation situation, and that not just when you're testifying, that's when you're talking to a guardian ad litem or the lawyers for either of the parties, is I don't have a professional opinion on custody, visitation, or parenting capacity. It would be unethical for me to form such an opinion because I, as a therapist, have a bias in favor of my client of necessity. And also, I haven't done the kind of evaluation that a custody evaluator would do that would enable me to form those professional opinions. Now, people often ask me when I tell them that information, they say, well, what if the judge orders me to answer the question? And what I say to them is, in the 35 years I've been doing this, a judge has never, in my knowledge, ordered such a thing to do, because it would be grounds for mistrial to do that. So if you take that position, that's going to be okay. Now, the other thing you have to be careful about when you are working with families that are involved in divorce or custody is to be careful in your note-taking, not to put anything in that looks like you're taking sides between the parents if you're working with the adolescent, because that will become part of the legal proceeding potentially, and they will use it against you when you testify. How come you said this in the record? How come you said the father was abusing the child? Or how come you said the father was really acting inappropriately? And so you have to be very careful in record keeping when you have people who are involved in difficult relationships with one another and you're working with their kids.
Yeah, great. Those are all excellent points, Eric. Mark, anything you want to add?
When I get calls on this, I will often, when callers are concerned about the go, no-go areas in terms of what they can and cannot speak to or should not speak to, I'll often refer them back to their treatment plan as a cheat sheet. The better you understand your treatment plan, the more apt you're going to feel those red flags when somebody's pulling you outside of it. You'll be able to recognize a little bit better. And the other option that I'll often discuss is, you have an attorney who you have authorization to speak with and they're asking you questions, I suggest asking for the questions in writing. A lot of attorneys prefer to have things in writing. That will allow you to select your language, to be thoughtful about your responses. I know I tend to, well, I hope I'm more thoughtful when I'm writing things than when I'm off the cuff, but that's something to consider as well.
Really good points, Mark.
Very good ideas. I think too, related to what you both said, one way to think about it is the clinician can testify or talk about the facts of their treatment, but not opinions about the psycholegal matter, right? So sometimes that can be helpful too. And of course, diagnosis is a fact of the treatment. So That's why it is allowed there. So, all right, great. So we are going to dive in. We have a lot of live questions. And so we are now going to dive in and see how many of those we can answer. This one is probably not answerable, but I'll mention it anyhow. Is California any closer to joining SciPact? Eric, do you want to comment on that?
I don't think California will ever be close to joining SciPact. California doesn't take advice from other jurisdictions.
Mm-hmm. Yeah, and so we one thing you could do if you're interested, if you're in California and you're wanting that to happen or not sure, I would say contact your state psych association out there. They'll probably know what's happening on the ground more than we would, and can maybe speak to that. So
I shouldn't be glib about it. What that means is California doesn't want to give up its own jurisdiction. And when you join SciPact, that's what you have to do. You have to give up jurisdiction over, you don't get to make the rules anymore. SciPact makes them. And I think there are certain states that that's hard for. Massachusetts is going through a fight about that now too.
Mm-hmm. Mm-hmm. Yeah, okay, great, thank you. Okay, now this is a question we've gotten lots of interest in also because it's become more of an issue recently with various EHRs changing their terms of service, et cetera. But the question is, there's a great concern about mental health providers who provide services through internet services that sell client information. Is this a violation of confidentiality? Mark, do you want to start on that?
Sure. Yeah, I think that this highlights the importance of being very choosy when you are deciding on what type of platforms to use, whether it's record keeping or whether it's video conference technology. You want to select those that hopefully are created for the purpose of healthcare professionals, but also that offer a business associate agreement, which will bind them to, one, comply with security standards and honor privacy that's associated with HIPAA. But if there was a breach and something went wrong, that they will take the appropriate steps to remedy that and inform you. So I think that's one of the really important first steps, is be selective about those platforms that you use. And I'm sure we've been getting some calls, and I know there's been a lot of talk about some of the updated terms of service associated with Zoom and Simple Practice. Now, it's hard to know exactly where this is going to go because AI is becoming just an expanding reality for us. But if you have a BAA, the expectation is at least at this point is that they're going to honor it. Although it is concerning that we don't know the exact extent that the information may be shared within those businesses and how that may be compromising privacy.
Mm-hmm.
The only other thing I would add to that is that it's important to remember that a BAA, when somebody signs a BAA, they become themselves subject to all the penalties for any violation of HIPAA. So they are going to be careful. And if any platform is not willing to sign a BAA, you shouldn't join it.
Mm-hmm. Right. And I think in addition to that, Eric, I mean, as we've been talking about recently, the BAAs actually, there can be a sort of a wide breadth of what companies will put in a BAA that can still be technically legal under HIPAA, but may not be as protective as what we as psychologists would want. And so I think, and this is where I think it gets really tricky because one of the things I would say here is I think you need to be asking the companies, if they're selling the information, what's getting sold? Is it de-identified or not? If it's not, if it is de-identified, how do they define that? Do they just mean the name is taken out? Because that may mean it can still be identifiable in other ways. So there's a lot of questions here, but I think what Mark said, I would agree with fully, is you got to be really choosy and you've got to do more research than probably any of us want to be doing on tech issues. It's becoming really essential these days. Eric, one thing that's really important to add here, I think, is this is one of the reasons it's important to be a member of a state psychological association, because you can actually go on their website or the place where members talk to each other, the name of which I've forgotten because I'm old, but you can get opinions from other people, and in many states they will have somebody who can actually give a legal opinion, depending on the size of the state association. Mm-hmm. Yeah, no, that's great. I think getting, information from other resources is important. All right, so changing topics, please address ethical considerations for providing pro bono services to Maui survivors if approved by the Hawaii Board of Psychology. Eric, do you want to start with that one?
I think it's okay. What I don't know completely is I don't know that the laws about, you would probably be doing this mostly by telepsychology, because I don't think many people are going to commute to Maui to be able to do this. I don't know Hawaii's SIPAC situation. If they may want to call the trust for a consult about this, because we can look it up. I think generally the rules usually are that if you are if you're doing it pro bono and there usually is a state of emergency which allows you to do it without much risk of a licensing board complaint. I have not, in my knowledge, and I'll ask Mark too, we have not heard of anyone doing disaster consulting with members of a different state having a complaint in that state or anywhere else. So I think it's relatively safe. We don't yet, Hawaii hasn't yet issued guidelines yet, so I don't think or at least if they have, I don't know them.
Yeah, the only thing I'll add, and then Mark, definitely I want to hear from you too, there is an emergency proclamation in Hawaii, but the language of it is not as broad as they often are. And I don't remember the exact wording, but there was something like you have to, in essence, you have to be employed there or hired by a certain, so you got to look at the exact language.
Yes.
This volunteering from out of state, at least the current emergency proclamation may not cover you. So there's some complexity here, but I agree, generally, there's somewhat lower risk. Mark, did you want to jump in there?
No, I agree with everything that's been said. Checking with Hawaii Psych Association or their website may give you updates as they roll out. The other issue I think is important to those who are in the mental health field. We care. And we want to be of aid, especially in a really challenging time like this for Maui. But we want to also remember that it's important for us to be competent in the delivery of these services to those who are affected, and also that we have the skills necessary in order to navigate even just technological issues and the platforms that we're using. So we don't want to lose sight of that while we're trying to do good.
Yeah, that's a really important point. And also because, actual harm can be done when you're working with, trauma survivors if you don't know sort of psychological first aid and you don't know some of the ways that you need to be careful. So I'm really glad you raised the issue of competency, because I think that's really critical. Okay, so the question here is about California, but I'm going to broaden it just a little bit. And Eric, I'll let you start on this. What advice would you give to clinicians who are in non-SIPAC states? So they can't benefit from SIPAC, right? They're in a home state, quote unquote, that is not SIPAC. How can they still sort of engage in cross-jurisdictional telepsych?
Well, there are in most states temporary practice rules that allow you, if you have a license that's the equivalent of a license in the state that you wanted to practice in, the ability to practice a certain number of sessions. For example, I think in California, it's actually 20 sessions in the course of a calendar year that you can do without any specific state agreement. A lot of states require you to get a temporary practice certificate or notify the state about that. And so there is also, there's an article Jeff Youngren and I wrote called Risk Management in the Digital World, which is published in an APA journal, where there is some argument that if you have been working with a client for a long time and an in-person referral, if they move or they're temporarily away, and an in-person referral is actually not likely to be as competent or effective as if you continue. There is some question as to whether or not the state in which the patient is temporarily in would be able to have jurisdiction, because there's something called the minimum context test, which I'm not going to go into at great length. If you have a situation like that, I certainly recommend that you call the trust and talk to one of our consultants about it, because it should not be done easily. And there's also some situations where I just think that it's, for example, if you're working with a divorced couple and one of the members of the couple is out of state, and you're working with the kid, there's almost no way to do that effectively if you cannot involve the out-of-state parent in some way. So technically that might be a violation, but there are several cases that basically say extending services to people that need them is not automatically give you the state a jurisdiction over that transaction.
Yeah, so Mark, did you want to say something? I'm going to add something, but what, you want to jump in?
Well, if you're looking at how to navigate these, the temporary practice allowances that Eric was alluding to, a couple resources, the State Psychological Association, the leadership in particular, some individuals you can consult with there, the Board of Psychology on their websites, if you can, some make it very easy to find, and an FAQ or something. Others you have to dig quite a bit, or you can give us a call and we could try to look it up for you and we can talk through it. But those are just some options if you're looking into temporary practice at least.
Yeah, that's very helpful. I want to say two things, because one is that really important, again, here, we can't stress this enough, in telepsych in particular, you really need to look at the law. You've got it, and the temporary practice laws for every state vary quite dramatically. Some, we don't have time now to go into them, but definitely they vary a lot. So do not assume it's the same state to state. Also, when you're making decisions, just to underscore something Eric said, when you're making decisions about will you or will you not do cross-jurisdictional practice, very important that you are making a case-specific decision. Because so many factors, even in what Eric just said, I automatically can think like, yes, in this situation, maybe, but in that, no, so there's a lot of complexity to these issues. There's not a one right, one wrong answer. So really be careful, be very thoughtful, have a very low threshold for consulting. And the last thing I'll say is be very careful about misinformation. There is quite a lot of misinformation. I see it state listservs and APA listservs about, oh yes, you can do X, Y, and Z. And I think, actually, you can't do that, that it's blatantly wrong. So wherever you're getting your information, be very careful of the source. And you may want to double check. If you're getting it off a listserv, you may want to go and double check and make sure that that's accurate before you rely on it.
And I just want to say that we have information in our database at the trust for every state in terms of their temporary practice laws. So if you have any questions about that, you may want to call the trust. The other thing to emphasize what you said, Liesl, is that if you're going to do this, whatever your justification is, has to be very carefully and thoroughly documented. If you're basically saying, I need to essentially violate technically the law because the client's needs absolutely demand it, and I could do damage to have to make an in-person referral at this point, you really need to have that well documented.
As an example, one that I love, it was a call about 1.5 years ago, and there was somebody who wanted to see, there was a long haul trucker. I often bring this up as an example, and was in clear need from a clinical perspective of help. But psychologists were turning this person down left and right because they're saying, well, I can't practice in that. I'm not licensed in that state. It's really impossible for anybody to meet this person's needs because at any given day, the person would be in a different state. And so having a very clearly thought out clinical rationale for why you'd see this person, that you're competent to provide these services. I'd like to believe that reasonable board, if they came across this, would not ding you for practicing without a license. They would see clearly the rationale is solid.
Yeah.
I would just add to that. We usually, if there are bad cases like that, we would hear about it if boards sanction someone for somebody. And I quite frankly have never heard of one. So if there's a really good justification, I think it's very, very unlikely that it would be a high risk for any kind of sanction to a provider. But again, all the needs to take care, I don't think you should do it willy-nilly.
Right. Yeah, we do want to underscore that. I mean, there are exceptions that where it makes sense and where we think you could have a very good argument even before a board. But I do want to caution, like Eric's saying, because oftentimes one of the things we hear on the calls is, well, I've started a relationship with this client, therefore, of course, I'm the right person, right? Well, that in and of itself, by itself, is probably not going to be enough. There needs to be more. So this is where, again, there's a lot of complexity here. And so we want to be sure you hear us saying, like, each case, really, you've got to make that an independent decision for that case.
Yeah, we're talking about 2 years of private practice with somebody as opposed to 2 days.
Right. Right. And even then it may be complicated.
No, I know it may be complicated, but what I'm saying is it really does depend on the nature of the relationship that you're trying to continue and the reason why you're trying to continue.
Absolutely. Yes. And I completely agree. You need to document that rationale. Last thing I'll say, because I think it's a helpful sort of rubric to have in your mind when you are thinking about, should I do cross-jurisdictional practice? There's sort of 4 categories of things you need to think about. One is regulatory. We've talked a lot about that. Is it legal? Can I do SIPAC? Can I do temporary practice? So there's a bunch of questions in each of these categories, but one is regulatory considerations. The second is clinical suitability. Eric was hinting at some of this. What's clinically appropriate? What's the risk level of the client? What kind of treatment are they looking for? So there's a whole bunch of questions in that. Is this short term? Is my patient going to be in, Alaska for 1 month versus they're moving there permanently and they're never coming back? So there's a lot of questions, but clinical suitability. Third would be emergency planning. Must have some emergency plans in place. Even if I don't know the first thing about emergency care in California, right? But if I was going to see a patient there, I'd need to figure that out. You don't want to wait till there's an emergency until you figure that out, right? So emergency planning is important. And last is service reimbursement. There's a whole bunch of if the patient is paying, needs to rely on insurance. So I don't have time to go more into that, but I wanted to just give that rubric because I think that's helpful. And then of course you got to weigh all those pros and cons per each specific case. Okay, so I'm headed back to the live questions because my goodness, we have 75 and I'm not sure we're going to get to all of them. A quick question on SIPAC. If a psychologist is licensed in multiple SIPAC states, can you change your home state easily for a vacation to another state that you are licensed in so that you can still go back and forth, or is it only your primary home state? Mark, you want to jump in on that?
I believe that you can change your home state. Now, how quickly and easily is that done? I don't know the answer to that. I'm not sure if Eric or Lisa will know the answer to that, but you can update your home state. But it's important that if you're going to see somebody through telepsychology, that you identify the home state and you're physically located there at the time of services. So Lisa or Eric, do you know how, I haven't done this myself, but how quickly you can update that?
Yeah, I haven't done it myself because I don't have an e-passport, but I have, so this is by word of mouth. So again, you should check, but I think it's fairly easy to do under SIPAC, that it's not too complicated. I would check into that. I do want to just underscore again, I think we've said this, but you do have to be licensed in the state you're going into. So if, let's say I do have my e-passport in New Hampshire and I go on vacation to, California, which is not a SIPAC state, I cannot then practice back, under SIPAC when I am physically located in California. But if I was licensed in the other state, we could do so.
But can I add to that? If you're not in SIPAC and you're licensed in a state and you are elsewhere, most states will allow you to practice with your clients, even though you're not located in the state. So that's a difference between being part of SIPAC and not being part of SIPAC.
Yes, that is absolutely true. And here I'm going to say this again, I'm sounding like a broken record, but here's where state specific law is really important, because there is, I think, one exception the 3 of us were talking about is potentially New Jersey wouldn't allow that. So there are some states that may not allow that. Many will. And if you need to know for sure, you can always contact the board, to find that out, I think is a good option. Anything else you guys want to add to that before we dive into another question? All right, next question. I directed my psych associate to be brief and descriptive when writing her notes in the chart. She asked me, I'm assuming the supervisor, to keep personal progress notes to help her remember the ongoing therapy process. Is that legally allowed to keep these kinds of notes separate from the official patient's chart? Eric, do you want to start that one?
Well, I think that I don't know any reason why she couldn't keep what's known as psychotherapy notes, which are essentially designed by HIPAA to be that exactly, notes that are important to the therapist for their process, but aren't essential for someone who would be looking at the record to know. Psychotherapy notes have some confidentiality protection, but not complete confidentiality protection. That would vary on a state-by-state basis. So you would really need to know if there was a request for those records, whether or not people would have access to them. But people should know that that psychotherapy notes are not so confidential that you can just write whatever you want.
Mhm.
You have to be as careful taking psychotherapy notes as you are taking regular notes. And also, psychotherapy notes are not a reason to put all of the information that you think would be problematic confidentially in there to protect the client. The psychotherapy notes are not process notes. They're very specifically defined under HIPAA as being limited to those things that a therapist only needs to know, and not the whole substantive aspect of the treatment, particularly the treatment plan.
Excellent. Mark, were you going to add something there?
Yeah, I think when we have these conversations, I think Eric makes a great point, is that sometimes we think that these are untouchable, and that's something that we need to, a myth we need to dispel. And when we're writing these, have an expectation that these very well may be seen by somebody else's eyes. And it's also important, in addition to being physically separate, whether that's in a different file digitally or physically separate, if you have a paper file, there's a lot of information that needs to be excluded for it to actually be considered psychotherapy notes. So they don't include summaries of diagnoses, for example, functional status, treatment plans, symptoms, prognosis, or even progress to date. And there's a whole host of other things. If you go to the Health and Human Services website, you just search for psychotherapy notes, there's a nice summary on this information. But I think sometimes we may include more information that may actually pierce the veil and turn it from a psychotherapy note into another document that should be released.
One other thing I'll say about it, there's certain clients who, if you keep psychotherapy notes and let them know that you have psychotherapy notes, they will devote the rest of their lives to wanting to get those psychotherapy notes. And often when people call with that situation, my advice to them is the simplest thing is to, let them see them. But that means you have to have them in a form that if they see them, it isn't going to create a crisis. Although often the kind of client I'm talking about will create a crisis no matter how you handle it. But the point of it is it keeping something confidential from certain clients is bound to cause real issues between the therapist and the client. And so in those situations, you have to be really careful about whether or not you want to keep psychotherapy notes.
Yes, terrific. Okay, so there's a lot of SciPact questions, and I'm going to ask some of them because I think there's some confusion, so it'll give us a chance to clarify. First of all, there's a question here, something about, will something change under SciPact when Florida joins? So I'm not sure what that question is about, but Florida has joined. Florida is, to the back. Mark and Eric, please correct me if I'm wrong, but I'm pretty certain Florida is currently a SciPact member state. You can certainly look it up on the SciPact website. Okay, so sort of some quick SciPact questions. As a participant in SciPact, can I temporarily travel out of the state but see my own patients back in my home state? So this is that question, the rub. Mark, do you want to start?
So if you are, I'm sorry, I may have missed this. Is this if you're a SciPact member?
Yes, so if I participate in SciPact, I temporarily leave my home state, okay, but I want to see patients back in my home state.
I see. So under SciPact, if you were going to use the telepsychology option, you need to be licensed in the other state, and you need to identify it as your home state. Now, what I think we've been discussing too is, let's assume that you had an independent license in that state. Do you need to operate through SciPact, or can you just rely upon your full licensure and be able to practice? And I think that that's a bit unsettled. And so at this time, we're recommending that people check in with SciPact to clarify that issue, because at this point, we're not exactly sure what would be the best directive to follow.
Mm-hmm. Excellent. Eric, did you want to add anything to that?
No, I think that's absolutely right. We don't, that is one of the problems with SciPact, is there are a number of issues which they haven't really resolved adequately. And hopefully they will in the future, but it's a very difficult decision-making process that they have, because it involves representatives of a number of states, and there's a certain amount of them that have to agree in order to pass a rule. So we don't know the answer to that, is essentially what we're saying.
Right, so you'd have to ask SciPact specifically. There's a question here on whether you can declare a dual home state. To the best of my knowledge, the answer to that is no. I think you have to declare just one, but you can change it. Mark and Eric, it looks like you agree. Again, I would check with SciPact on that. This is another question. I am not a member of SciPact. I'm licensed in New York, Colorado, but I live part-time in Florida. Can I be physically located in Florida and treat clients in Colorado or New York under my license. Again, not SIPAC. Eric, do you want to comment on that?
You'd have to check with each of those states, but my guess is that you can.
Yes.
That most states will allow you if you're licensed, because when people had to figure out how to regulate telepsychology, they couldn't regulate cyberspace, which is where the telepsychology transaction takes place. So they had to choose an earthly site. And what they said is the transaction takes place where the client is located, because otherwise states would not be able to protect clients through their consumer protection laws. So that being the case, if you're licensed in a state and you're not in that state, but you're practicing with your clients who live in that state, technically that transaction takes place in that state, and therefore it's perfectly legitimate unless there's some specific state rule that says you can't.
I tend to take a bit of a different, just as a really conservative approach. I typically recommend that people be licensed or fall within temporary practices in both jurisdictions, because the reason I base that is on the definition of the practice of psychology in some of these other states. So if it was out, that perhaps it could be argued that if you're in Florida, you were conducting therapy, even though the recipient's in another state, that it could be construed as you actively practicing psychology without a license. So as a conservative, I typically say both states would be the safest bet.
Right. But the point is, you would then, what you're saying is that Florida could go after you.
Yes, right, right.
And again, it's true that could happen. It never has.
Yeah.
So, and if you ask the state where if you ask the state where the client's located, they will tell you that that's okay. And I think Florida would have trouble doing it. Actually, you and I would probably disagree about this, because the transaction takes place in Massachusetts. How would Florida say that the transaction takes place in Massachusetts is a violation of Florida law?
Well, and here's where it gets tricky. So I'm going to sort of bring this in a little bit, because there's a lot of complexity and there are differing opinions. But I think, there are states, for instance, California, that have enacted some laws where the states themselves are moving to say that they have jurisdiction over practitioners in their state and practitioners out of their state that are practicing into their state. So again, the specific state law really, really matters. I think, Mark, you're right. If you want to be super safe, be licensed in both states, where you are and where the patient is. Short of that, I agree with Eric that I think if you're going to be, say in this example in Florida, check with all the boards, right? So if you're not licensed and you're going to be in Florida for 3 months of vacation and you want to practice back into the 2 states you are licensed, great, but just check with the boards. I know on the calls I've taken, we've given that advice many, many times, and to the best of my knowledge, no one has called back and said a board has forbade that.
And I've talked to people that have said that they have checked with the board, and the board said, we have nothing to do with that. That's
right.
Massachusetts law.
But the benefit to checking with the board is that you're covered.
Yes,
you can
of course, and you can note that, yes.
Exactly, so then you know you're safe. Mark, quick question for you here. Is SIPAC limited to practicing telehealth?
No, there is an in-person option as well. I didn't cover it just because our calls tend to focus on the telepsychology option. But there's an in-person option as well that if you're licensed, you identify home state, but it allows you to practice for up to 30 days in a participating state. So if I have SIPAC, say in Indiana, and I travel to Kentucky, another SIPAC state, I could practice in person for up to 30 days in that state.
Great. Eric, did you want to add something there?
Oh, that's particularly important if you're a forensic psychologist.
Yes.
Mm-hmm.
Those are the people that we're most wanting to use that, because that allow you to testify in person in a different state if the trial is there or something.
Yeah, exactly. Okay, I'm going to try to squeeze in 1 or 2 more. We've got like 2 minutes here. How do you adjust your informed consent document to reflect 38 different laws, for example, mandated reporting, et cetera? You cannot have every state laws in the documents. Eric, do you want to comment on that?
Sure, you can't. So technically, what that would mean is that each client you have in a different jurisdiction, you would have to have your own informed consent for that jurisdiction, which would talk about what the rules are under that jurisdiction. An absolute impossibility, practically speaking. But that's the way it's structured. And you're responsible for informing the people in those other states about when you would breach confidentiality and what the rules are. according to that person, the forum state where the client's located. And as I said, there isn't any database that will allow you to do that. So SciPact is probably best for people that have clients in 1 or 2 other states, not in 38 different states.
Yeah, and Mark, do you want to add something there?
No, I think Eric covered that really well.
Okay. Yeah, I'll just add too, keep in mind just the way the question was worded, you don't have to put every state law into your informed consent, right? You don't have every state law in your current informed consent, I would assume, for your home state, but there are some laws, like Eric has mentioned, the confidentiality. When do you breach? You know, if your state does have the equivalent of a TerraSoft statute, for instance, that says you will breach, you know, in case of harm to others, and then you're now practicing to someone into Texas, which does not have that law, you absolutely need to change your informed consent document because you don't want to be giving inaccurate information in your informed consent. So this is where it gets really hard, but I agree with Eric. I mean, if you're going to have clients in 38 states, that's going to be challenging. But if you're, you know, if you have clients in a few states, you can create a correct informed consent for those particular states where you're seeing people. And on that note, unfortunately, we have far more questions. Thanks for sending in the questions. We save those. We will try to create the next few roundtables to address the bulk of the questions. So I'm sorry we didn't get to more, but you guys have been asking excellent questions. I want to say thanks also to my colleagues here, Drs. Harris and Martinez, for taking the time to be with us. This was, certainly a fun roundtable and hopefully useful for you in the audience. And thank you also to our participants there in the audience. As I said, we do appreciate your thoughtful questions and your close attention.